In January of 2023, I retired from the U.S. Court of Appeals for the Sixth Circuit. And I'm still doing some judging, but not at that level. And so I am not engaging in a fraud when I still use the title judge, because I am doing some judging. It is my pleasure this morning to lead the discussion, an interactive discussion of challenges for judges in the 21st century. And we have a dynamic panel this morning, a highly experienced panel that is going to reflect on a number of topics related to that topic. Our panel this morning is comprised of Judge Darren Gales from the Southern District of Florida, Judge Jacqueline Becerra from the Southern District of Florida, Judge Richard Boulware from the District of Nevada, and Judge Paul Atkin from the Southern District of New York. So we're going to be talking to them about this topic, and hopefully we'll have some time for questions from you. I see people gathering, but I just wanted to make an observation at the outset. Today, and Justice Jackson has given you permission to admit that you watch television. But today, if you turn on the news on whatever channel it is in whichever state, district, or hamlet you may reside, you're likely to hear a myriad of voices and references to, quote, the other side. Indeed, we live in a time where people have staked out their own tribes and their own views.
Whoa, sorry.
Okay.
That was not commentary on that. Establishing my tribe first.
Okay, so they have staked out the side or the view or the village with which they will affiliate. If you log on to social media, you're likely to see people discussing divisive topics in harsh languages and casting aspersions on people whose views differ from theirs. People are likely to talk about the rule of law if it aligns with their worldview. And that can sometimes cause people to see issues only in terms of the view of themselves and those who affirm that like view. That can have implications on the judiciary and how people consume the outcomes of judicial decisions and judicial arguments. So today we're going to be talking about challenges to judges who are doing their job, who are invested in the rule of law, who are making decisions on the issues of the day that come to the court. And we'll talk about how those and other things affect or make it difficult for judges to do their jobs, and how judges' lives and the lives of their families are affected during this time of enormous division. I'm going to start by having our judges introduce themselves and tell you how they came to the position they are today. And I want to start with Judge Darren Gales. Would you kindly introduce yourself to our audience and tell them briefly about your path to the bench?
Well, good morning. Thank you, Judge Donald. I'm very happy to be here. And welcome to Miami, because this is where I sit, just a couple of miles away from here. I've been on the U.S. District Court for 10 and a half years. Prior to that, I served as a state judge for 10 and a half years here in Miami-Dade County, having served in both the criminal and the civil divisions on that court. And prior to that, I was an assistant U.S. attorney here in Miami, having rotated through the appellate major crimes and narcotics divisions. And prior to that, I began my career as an assistant state attorney, among the last class of attorneys that Janet Reno hired before she became Attorney General.
Okay, thank you, Judge Gales, and welcome. Judge Boulware from Nevada, could you please introduce yourself to this audience?
Sure. I joined the bench around the same time. Judge Gales and I were in the same, what we call baby judge school, so about 10 and a half years ago. My path was straightforward. If at the time somewhat unusual, I was a federal public defender my entire career. I was a federal public defender in the Southern District of New York, and then I was a federal public defender in Las Vegas, and I took the bench in Las Vegas, is where I sit now.
Well, Judge Boulware, I'm sure people ask you, as they did me, how did a public defender get on the federal bench?
Well, I will tell you, at the time it was unusual, but they were looking for diversity. At the time, Senator Reid was the senator for my state, and he and President Obama and his staff were looking to expand the types of backgrounds that judges had, and so they came to me and asked me if I'd be willing to do it. I initially said no, because I loved being a federal public defender, but they eventually convinced me to go through the confirmation process, not fun, and then I ultimately became a judge. But at the time that I was selected, it was so unusual for federal defenders to become judges that the New York Times wrote an op-ed about how they were welcoming the diversity of the types of judges like myself, actually Stacey Yandel, other types of judges from different backgrounds. Now, of course, there are a lot of federal defenders who are judges, which is great.
Wonderful. Judge Jacqueline Becerra, excuse me for walking across from you, but I know that people draw inferences from everything that goes on now, and I don't want there to be a headline that said there was a program conducted here where people were constantly looking to the left. So I'm going to move over here so you can look to the right for a moment and introduce yourself to this audience.
Thank you very much. I'm Jackie Becerra. I've been a district court judge only for a year. Actually, my anniversary was just this past weekend. I was a federal magistrate judge for 5 years before coming onto the district court. Before that, I was at a law firm for 15 years. I did some criminal defense work, mostly like in the investigation space and corporate investigation space. I also did civil work. And before that, I was at the Justice Department. I started in the civil division at federal programs as an honors program grad. And then I was at the U.S. Attorney's Office in D.C., and then in the U.S. Attorney's Office here in Miami, where Judge Gales was one of my colleagues.
Wonderful. Judge Etkin, from the Southern District of New York, where some would say where the action is.
Yes.
Talk to us about how you introduce yourself and tell us how you came to the bench.
Sure. So after graduating law school, I clerked for 3 years, and I could have kept on doing it because it was having a blast. I like Justice Jackson, I clerked for each level of the federal courts, including Justice Blackmun's last term on the Supreme Court. Then I sort of jumped around a bit. I was at a law firm in DC, and then I was at the Office of Legal Counsel at Maine Justice, and then the White House counsel's office under Bill Clinton. Then moved to New York in 2001, went to another law firm. Then I went in-house. I was an in-house lawyer at a media company, and I'd sort of given up the dream of being a judge, but I got a call saying, any interest in being a judge, and put in for it. Unlike many of my colleagues, I had basically zero criminal law experience. But I was appointed in 2011. I think I was confirmed the same day as you, Judge Donald, in September 2011, and then I've been on the bench for going on 14 years, and I love it, and I've been surprised to love the criminal law aspect of the job so much that I'm teaching federal criminal law at NYU now.
For those of you sitting out here who think that you might want to be a judge, I want you to think about what he just said and what Justice Jackson said before. The importance of networking. I'm sure that call that said any interest in being a judge had something to do with connections and networking. But let's start now at the macro level on our topic. There are many challenges, I'm sure, for judging in the 21st century. And I want to start by getting some observations from you on what are some of the, I guess, most consequential challenges that the judiciary, not just you personally, but that the judiciary faces here in the 21st century, and can talk about why. And whoever wants to start. If not, I'll call on Richard Boulware.
So I will say this. I think one of the challenges is the technology itself. So cryptocurrency and these types of cases are very challenging for judges because you do have to learn a lot about this technology to be able to answer the questions that are put before you. And I have a sort of a Bitcoin data mining case that I have now, and my law clerk and I were literally going over this material for days just to try to learn the basics of this particular technology to be able to address the legal questions that we were facing. And so I think one of the challenges will be for judges as we have advancing sort of technology exponentially in terms of its sophistication, we have to really catch up, right? And it's not simply about reading the next restatement of torts, right, or the newest version of the treatise on whatever the contracts may be. This is incredibly complicated material, but we have to learn it, and we have to learn it quickly. So I'm hopeful that one of the things we can start doing for the judges is having more seminars, particularly as it relates to the technology that's basically in almost all of our cases, whether or not it's the actual substance or it's in, for example, the discovery. I think that's a significant challenge, and it will continue to be a challenge moving forward.
I want to get to everybody else, but I want to explore that just a little bit because, when we think about this technology and cryptocurrency and all of those things that are going on now, that for those of us who are from the Flintstone area, this is really foreign. And Justice Jackson talked about the importance of educating your judges. You have law clerks who perhaps know some things, but doesn't that potentially add a layer of expense to the parties when you're trying to get the judge up to speed? I mean, how does that impact the just and speedy administration of those cases where you have a judge who's not as familiar with these things as are you, but the judge who knows nothing about technology may very well get one of those cases? How does that affect the parties, and what are the expense and the bringing the judge up to speed? Talk about that.
I think what it means is that you have to have a higher quality of lawyer in terms of their ability to present this material to you, right? If you cannot effectively present the information through your briefing, you're going to be at a disadvantage because part of this process is educating the judge through the briefing and through discussion and oral argument. And so I think we're going to be relying more and more upon the lawyers to be able to educate us through their briefing, and that means that the lawyers have to have this skill in terms of presenting these complex ideas to us in a way that we can digest them when we need to and be able to move on. So I don't know that's going to add expense, Judge Donald. What I think it's going to add is an added burden, if you will, on the lawyers to really develop their ability to communicate to the judges, right, these very complex technologies and these areas in a way that we can move through them quickly.
Does it potentially bring in the whole idea of experts earlier, even in the preparatory stage?
I do find that I have increasingly had more expert hearings in cases and class actions or other cases where I will have an expert or experts from either side come in to help me resolve discovery disputes or other disputes. Actually, I have one on these same lines where I'm having experts from Meta and from other technology companies come in and explain certain aspects of the technology to me to help me resolve earlier sort of both discovery and dispositive motions. And I find that's a tool that I'm using more and more.
One of the other panelists, yes.
I was going to add the subset of that I think has struck me is discovery, and for civil cases you have, proportional to the needs of the case, kind of the new method of sort of focusing the scope of discovery when it's appropriate. But for criminal cases, and this brings on the issue of expense, you have cases now, in my 13, 14 years on the bench, I've gone from paper courtesy copies to everything electronic. And I've seen more and more in criminal cases, the fact that you have 16 cell phone extractions, right. And the government is, increasingly just dumping everything on the defense as Rule 16 discovery. And so you have much more commonly a situation where it's extremely expensive and difficult to go through everything. And there's not a Brady problem because you've thrown everything at them, but it's much easier for defense counsel to miss something when one gem of a document is buried within all this terabytes of data. So I think that's another problem, both in terms of expense and in terms of the complexity of dealing in the criminal space with the technology affecting discovery.
Judge Gales, staying with that issue of discovery, when you're getting all this information out there, and there are multiple parties, involved. You have a lot of, conspiracies or, collective groups. When you're dealing with that, are there other problems that require, discovery managers on the defense side? I mean, when you have 10 people who were involved in a drug operation and there's all this data, does everybody run up a bill for however many $1,000s it is to go through that? Or are you seeing the use of a central discovery manager or whatever that also protects for privilege and that kind of a thing? I may be stating it wrong because I've been on the appellate court I was on the appellate court for 11 years, and I'm sure I don't know what you all do with those things, but I do know that there seem to be problems with that.
So I'm going to pivot because I don't handle discovery matters. So our magistrate judges primarily handle the discovery matters. But I will say to the discussion that we're having here, all of these things, including how to properly handle discovery, are things that parties need to give a lot of thought to in advance, whether it's the prosecution or the defense, or if it's a civil matter. And keeping in mind, by design, we are generalists. You're going to find very few judges that are specialists or have an expertise in a particular area. We don't have specialized courts largely. And so it's incumbent upon the parties to think about these issues in advance. So whether it is ultimately the district judge that is trying the case or deciding Daubert issues, or if it's the federal magistrate judge handling discovery matters, when you're dealing with these big, complex cases, you have to give a lot of thought to how am I best going to educate this judge who may not know very much at all about this particular area, how to do that, and how can I help guide the judge to make an informed decision, whether it be about discovery issues or expert evidentiary issues or whatever. So it's an issue that I see quite a problem I see often with lawyers, that they really kind of forget that it's not just the jury at the end that you have to educate, but from the very beginning, they have to give some thought to how we will handle these issues.
Yeah, I'm going to move on, but I'm going to go to Judge Becerra because she mentioned she was a magistrate judge. So, and I saw this issue when I was approving fees at the appellate level, and there was, some giant requests for money, but there was a repository, I guess, of this electronic discovery and feeder issues. Talk to me about whatever it is I'm trying to ask you about.
So I was a magistrate for 5 years, and I love discovery, civil discovery, right? I love it because in the civil context, the game is played at discovery. Good lawyers know that's where you make your case. The case isn't made at trial. Criminal cases are completely different, especially federal criminal cases where there really historically had never been any discovery, right? The game was trial, right? That's on its head a little bit now with this electronic stuff, because when you get a criminal trial and the government has just dumped, right, 3 terabytes of information on the defense, well, now the game isn't trial so much, right? Now there is, because of technology, discovery in criminal cases. And so I've started having in my criminal cases sort of as a status, right, mini discovery hearings, if you will, because you can't let the government just dump the 5 terabytes unless you want to have the trial 6 years from now, right? Because the PDs doesn't have necessarily the resources to handle that in the way the government does, even, and neither do a lot of the CJA lawyers. So I think it is requiring us, and you have to be a little careful, because I'm not trying to put my thumb on the scale for one or the other, but unless I manage that a little bit, and I have like 2 or 3 cases right now that that have that issue, right, of the big government electronic dump. And so I do think it's requiring us to get in it a little bit just to be able to move the case along and to make sure that the defense has the resources that it needs.
Other comments on that before I go further? Judge?
Well, the one thing I would say to you all who are primarily, at least at this conference, defense attorneys, is it's more and more incumbent upon you to file discovery motions in criminal cases earlier. One of the things that I find to be somewhat disconcerting is if I'm getting a request for or a motion to compel or something of that nature, and we're 30, 60 days away from the trial on a complex case is going to take 2 weeks. That's really aggravating. But it's important for you all to start letting us know early on these types of data dumps or things that happen. So if you're going to request that, for example, material be organized in a particular way or that it be produced in a particular way, you should do that as soon as possible. So we can start the process, and so I can see, or we can all see, how you all are working together regarding the issue of discovery, particularly in criminal cases.
I said I was going to go down the line and ask about what you see as the complex challenges to judging now. And Judge Bower, you started, and I want to give other people an opportunity to sort of tee up an issue. So, Judge Etkin, what are you seeing?
Well, we've covered technology. That was going to be my first thing. That is what has changed the practice, both from the advocate's perspective and the judge's perspective. I mean, the other thing I'll say is, and you probably were going to ask about this separately, but the division in the country along sort of political, ideological lines has affected things like filing motions for nationwide injunctions before particular judges, and related to that, the shadow docket of the Supreme Court being a much larger percentage of how that court is spending its time and where the law is being made as a practical matter. And also the independence of the judiciary being challenged, I think, is something that we're seeing more and more in the last, several years, and that's just a constant challenge.
There are some law students in the audience today, so I want you to go back to the shadow docket and just kind of talk a little bit about how this affects this area and why should people care about the shadow docket.
Yeah, I mean, Steve Vladeck, who's a professor, I think now at Georgetown, has done a lot of work on this, and he's a great source to sort of get the latest and greatest. It's just, just the other day there was a 5-4 decision, I think, denying a stay of a temporary restraining order in the district court, and and there's a dissenting opinion and a very short majority. I just think you're seeing more and more of the kind of cutting edge issues going up and being decided in the first instance on basically emergency stay requests or on a preliminary injunction, things like that. And without the benefit of full briefing and argument, I don't think the Supreme Court ideally decides important, especially constitutional issues that way. But for whatever reason, it's become necessary because those issues are being elevated quickly. It's a combination of factors, I think. I don't know exactly how to explain it, but it's becoming a much larger percentage of the decisions that they're making, and therefore kind of more important thing to understand the jurisprudence of the court. Sure.
I certainly agree with you because I found not just that, because of the way the Supreme Court does it, you see other courts making substantive decisions on things like a TRO. I mean, they're trying to make substantive rulings on those narrow emergency matters. Judge Gales, did you have something you wanted to say?
Well, I mean, I will.
Whether it's on that or the next.
Yeah, well, to what Judge Etkin was saying, There is a problem overall with trust and confidence in the judiciary. And it's not limited to the federal courts. It's a problem being dealt with by the state courts. And in fact, they've been doing public surveys dealing with that issue. And across the board, we are underwater with that, whether it is shadow docket, the use of the Supreme Court's use of shadow dockets, if it's nationwide injunctions by district judges and often them being sought in single judge divisions of district courts, whether it be the constant us being constantly identified as an Obama judge or a Biden judge or a Trump judge. I mean, and also just, Justice Jackson, when she spoke earlier, she was asked a question about ethics. I mean, we're all bound by a code of ethics. The Supreme Court is not bound by the same code. All of these things, to some degree, I guess, erode the public's perception of the judiciary. And we all have to do better and push back. We can't, obviously. That's why we need all of you to stand up and talk about what we do, that we are independent and we make decisions based on the facts and the law. That's what we should be doing, right? And to be that voice that we can't be. But I think we all have a role to play to make sure that we are reminding people that of what we do, because people aren't getting those civics lessons. So I think overall, as I said, trust and confidence in the judiciary, it's a problem right now, and we need a strong judiciary. We are a co-equal branch of government, and we need lawyers to support us.
Absolutely, an independent bench and bar. And, when we say that independence of the judiciary, I think some segment of the community believes that we're saying we're not accountable. And we certainly are accountable to the laws, as you mentioned, with that code of ethics and the rest of it. But people hear things, and sometimes the message sent does not always equal the message received, or it's all filtered. A person is filtering that through their belief about the value that a judiciary, through a certain judge or whatever, brings to the overall process. So, Judge Becerra, did you want to comment?
I was going to say, you're right, because people hear independence and they think, oh, that means you can do whatever you want. No, that's not what being an independent judiciary means. I couldn't agree more with Judge Gales, though, about the particular responsibility that lawyers have in this. I think we've moved so far away from the concept of the lawyer being a civic leader and being a leader in their community. There's only so much that any of us can do as judges. I tell my law clerks, we get up every day, we come in here, we do our jobs with dignity, and we go home. That's all we can do. That's what I can do. I speak at schools, I think we probably all do. We can do things like that. But when I hear lawyers talk about judicial opinions or talk about judges in the same manner that some talking head does, who has no legal education, to me it's very upsetting. I think judges, we're certainly, I think we should be criticized for our opinions, right? We're not better than anybody else. If people disagree with us, you should be free to disagree and to openly disagree and comment on that. But the commentary of why you think we're wrong has to be more elevated than just the shorthand of who appointed us. And I don't expect members of the public maybe to be able to do that, or a commentator on a news channel maybe to be able to do that, but I expect lawyers to be able to do that, because people will look to you as lawyers for that kind of commentary. People will look at you at your PTA meetings and your neighborhood meetings, right? At your firms when you're commenting. And so I really implore you and encourage you that when you speak about the law and you speak about judges, that you take an extra 5 minutes, right? And that you think about discussing your opinion in a way that is also grounded in the law and that is grounded in your education and not just on your political view.
Judge Atkin,
Well said.
do you want to add something else to that?
The one thing I was thinking about is a specific example. Obviously, there are a number of temporary restraining orders that have been issued in the past several weeks. One of them was issued by a colleague of mine when he was the emergency judge, spent a couple hours on the case, and it became the subject of sort of high-level Twitter X discussion to a point where he and his family started receiving really disturbing communications, some at the level of threatening. And that's really troubling. And it reminded me of something that some of you may remember. The late, great Harold Baer, who was my colleague on the Southern District of New York in the 1990s, you remember this because you were there. He issued a decision. He was a recent Clinton appointee. He issued a decision finding that suppressing evidence on the basis of lack of reasonable suspicion when a person ran away from a police officer, and saying, well, that doesn't give rise to reasonable suspicion. I think that's basically, you probably know better than I do, but and then there was so much public criticism of that even the White House press secretary made comments about maybe looking into impeachment of the judge for that decision on the merits. And a very unusual thing happened, which is that the chief judge of the Second Circuit, John Newman, and I think a couple of other circuit chief judges issued a statement saying, you shouldn't be calling for impeachment for substantive legal rulings of judges. And it struck me that sort of quieted things, and it's very an unusual thing for another judge to say something like that. But Chief Judge Newman at the time decided that was appropriate in that situation. So it brings me back to that point, and this relates to what Judge Becerra is saying about comments on the merits of legal rulings and not ad hominem political attacks, obviously, and that all goes back to the independence of the judiciary.
I know all of you are courageous judges, but I just want to ask for your comments. Do you think that when you have situations like that where judges are unfairly criticized for making reasoned rulings and applying the law, following precedent in the way it should be applied, and they get that kind of backlash, does that in any way chill the rights of these lawyers and their clients to believe that they can get a fair decision on the merits? I'm not, could it chill that?
I don't see how it wouldn't.
How it wouldn't?
How it would not. I mean, we have to be honest, and some of the things that maybe you all don't know, and Judge Etkin has sort of referred to it, but let's be honest, the threats against us have gone up exponentially. Exponentially. We don't communicate those to the lawyers all the time, but threats against judges personally and their families are almost a regular occurrence in almost every district. I have a current case of someone being prosecuted for stalking me and my family because of a case, right? And so the idea that judges are going to be impacted by that, I think is natural. Now, I made a decision, I'm going to continue to do what I'm going to do, and in this particular case, there are unique circumstances. But that's the part of this that I find, going back to Judge Becerra's point, I find deeply disturbing, which is you can disagree, but the attacks have consequences for the judges personally and their safety. And I don't really hear people, even lawyers, talking as much about that. Now, part of that is because we don't communicate the number of threats that we receive. But when you're in a situation where you've had to have the marshals guard your children, or you have to take down all of your social media posts because different people are going to be attacking you because of the nature of the cases you have, and you haven't even ruled yet, we're in a dark space. And we have to stop pretending like we're not in that space, and we need to figure out ways to move forward. But we need to address this directly and openly.
I mean, I'd only add that, we're not infallible. Sometimes we get it wrong because we're dealing with a lot of very difficult, complicated issues. But it's the nature of the criticism. Not that we get criticized. We're all big men and women. We can handle criticism, but it's the type of criticism. Right. And if it's done in a way that subjects us to harm, that's problematic. I mean, the solution, if we get it wrong, you appeal, and the circuit court will tell us if we're right or wrong, and then the Supreme Court will tell them if they're right or wrong. But the kinds of attacks from lawyers who should know better now, it adds fuel to the fire.
Okay. Justice Sarah, did you have something you wanted to say on that?
No, I look, the security thing is very real and incredibly scary. People are putting comments out there, and they're comments to the public, and I think we all know, just from reading the paper, kind of where we are with respect to violence against others, not just judges. And we saw that with Judge Salazar a few years ago, right? And people always ask me, are you scared of the criminal cases? I'm like, not really. I'm not scared of the criminal cases. It's the civil cases that I'm more worried about, actually. And so it has a huge impact in our lives. I mean, I have a teenage daughter that I have to say, no, you can't have an account, a TikTok account that does this, or you have to be careful on what you say. She's taking a journalism class at school, and I'm like, you can't write articles about this or that in the school paper because you're just a minor, and I don't know if somebody will think that that's now my opinion or take it out on you. Like, you just can't do any of these things because my last name isn't particularly common, so it would be pretty easy for her, people to figure out who she is. And so the security part is incredible. And so, when people say, look, for some of us, our lives and the lives of our families might depend on it, I don't think is an exaggeration when you see what the numbers are now in terms of threats.
I want to turn to the practice area, I guess, of the people here and talk about complexity in white-collar crime cases. And we know, and the high-profile nature of many of those, and they can become high-profile from a media standpoint because of who the parties are, what the subject matter is. Sometimes they can become high-profile because of maybe the judge handling it or the jurisdiction, any number of things. Are there particular issues from the standpoint of media and high profile, if you will, that can make the handling of that case particularly problematic? And how do you deal with that? A lawyer who's got, maybe handling a case for a representative or somebody who's under attack there, or maybe a high government official. All of that can add complexity and can make some management problematic. How have you all have all dealt with them? Tell me what the complexities are or can be, and then how you deal with it, and any advice you can give to these parties. These people in the audience.
I'll start, I guess. I haven't had a whole lot of super high-profile cases that have caused issues. I did have this case, some of you may have heard of Lev Parnas and Igor Fruman, who were in my courtroom, and two of the four defendants went to trial, and they were involved with Rudy Giuliani going to Ukraine and looking for information relating to Hunter Biden, and then there ended up being a Federal Election Commission complaint, and it ended up, giving rise to charges involving election fraud involving Russian money and a separate sort of independent fraud. And it was high profile, and there are lots of media calls and random, communications and emails, and I sort of just tried to filter all that out. The one weird thing that happened was that it ended up being related to the impeachment proceedings that related to one of the impeachments against President Trump. And so there were communications with a House committee about revising our protective order so that they could use some of the material involved in the case. So that was a very strange, unprecedented situation where I had to bring the parties in and sort of get agreement on how to deal with this type of issue. But the other thing that I think it does is it gives rise to kind of strange arguments because it's high profile. Some of the lawyers in the case sometimes tend to sort of argue things about political aspects of the case that may or may not be supported that you wouldn't get in a normal case. So one of my goals was to just make it like any other case, to just act as if nothing's different about this case. There might be some reporters in the courtroom, but we're just going to deal with this as we would any other case. And that was my goal from start to finish.
Did you have to try and impose any restrictions on the lawyers, like doing pre-trial press, pre-argument press in the case? Did you have to monitor that?
I didn't. The lawyers acted pretty well. I mean, I never got to a point where one side requested that I put out some sort of a gag order or anything, and I never had to do that. And I wouldn't do that on my own unless there was a request and there was a really good basis for it. Because I think, if people want to talk, they should generally get to talk unless it's really doing something with respect to the jury pool or, something real misconduct. And that didn't come up, fortunately.
Anybody else? What have you had to do to manage those situations in high-profile cases? For whatever the reason.
Well, I have had to issue a gag order in a case where in the midst of the trial there were statements about the validity of certain pieces of evidence that had been admitted. And one side raised this with me, and the other side acknowledged that perhaps everyone should no longer speak to the press after we had a spirited conversation. Because we were in the midst of a jury trial, and these things were being published right on the front page of the local paper. Political figures, other figures making comments about evidence in the case. And so we had to put a stop to that.
But the press is going to say, we are the eyes and ears of the community. We need to be able to transmit to the community who cannot be sitting in the courtroom. We need to be able to transmit what's going on. So how do you balance that public's right to know in some manner and your obligation to conduct a fair trial?
Well, in this case, it was directed to specific pieces of evidence and
Okay.
how it was admitted. So it wasn't sort of a general discussion of the case, which had been going on for the entirety of the trial. There had been articles about it. But there were specific pieces of evidence that were being commented upon. And that's when I felt that a line had been crossed. And when the party came to me and said, we need to address this, then I thought that was appropriate to do so. I don't think it'd be appropriate to address sort of general comments about the nature of the case. And, those were going on, and I didn't really have an issue with that. But when we started having parties indirectly giving information potentially to the media about evidence, that's when we had to, I think, take some action.
Judge Becerra, what's been your experience?
So, this is Miami. It's a very interesting place for all sorts of cases. So you almost start with the assumption that every case can end up on Only in Dade or in some Instagram account. And so look, I've only been doing this role for a year. I kind of go into it treating like every case like it could turn on me. I have a very simple case. If you just look at the pleadings, you would think it was very simple. And that the other day I got a call, it was an emergency matter, they're in a deposition, and one of the parties was streaming the deposition like on Facebook Live. And I'm like, are you kidding? My first question was like, and how many people are watching that? Because why does anybody care about this issue? So I have to go into it, I think, just because our docket is interesting, with the assumption that it could be generating interest. I also have, my mom, my parents are Cuban immigrants, and my mom, the news she consumes is very different than I do, because she's on Spanish radio and Spanish TV and reads the Spanish newspaper. And she's always like, I just read about your case. And I'm like, why? Because it's of interest to some reporter in Argentina. I don't know. And so I just never know. And so I kind of treat everything with a baseline that it could go south at any moment.
Judge Gale, share your experience.
Well, I've had, several high-profile cases to some degree or another. But the thing in addition to traditional news sources, everyone's a reporter with the internet. And things are on Twitter or X and otherwise, and people are talking about things. You can't control that, right? And I would say, as a judge, I'm primarily concerned about the jury pool and the jury. We have open forums. You can't have television cameras in the federal courts, but our proceedings are open. Anyone can come in, they can report whatever they want, accurately or not. That's up to them. But my concern is more limited to the jury. And even then, I'm not acting on my own. I'm waiting for a party to make a motion, and then considering all the equities, decide what's appropriate.
Yeah. Without disclosing identities or, protecting people who may have made faux pas, in the whole white-collar crime practice area, are there some things that you have seen by practitioners that you believe could be some maybe mistakes made or some faux pas that you could describe without giving identity to the parties, that could be a learning opportunity for the individuals here? Can you reflect back on this and think of something that you've seen happen that you think, in this situation, it would have really been better had the parties, done whatever. Judge Bulwer mentioned earlier the whole notion of getting the discovery in there sooner, coming with motions when it's really almost too late, or somebody maybe who had an international witness and they didn't know how to go about getting that, and then they came, but too late to really get the benefit of being educated about the procedure or the protocol for doing that. Something like that you can impart to these people that might help them should they run across this issue, or if they're training the younger people in their office to practice in this area. I want your wisdom there, and then I'm going to come back at the end and give you another one of these opportunities. Judge Ekin?
Well, one of the things that comes to mind is something I talked about yesterday when I did a sentencing panel, which is actually the experience I've had in most of my white-collar cases involves sentencing, because a couple went to trial, but most of them are guilty plea situations where the work is done at sentencing. And most of the white-collar cases have been handled very well. I think at sentencing, it's a very tricky line to walk. And I think that the advice I give to white-collar practitioners, defense lawyers, is always remember that 90+% of the sentencings I'm doing are with extremely poor, indigent defendants who came from extremely difficult backgrounds. So you have to be a little sensitive when arguing mitigation to a privileged white-collar defendant, and I think you all know this, but you have to be very careful in talking about problems they had, in their upbringing, because you have to always remember that the judge is dealing with people who have serious mental health issues, have serious addiction issues, grew up in very, very difficult circumstances, didn't finish high school, and against that context, it can land awkwardly and not be helpful to argue too much about the difficult circumstances of someone who's a privileged defendant. So that's the one thing I've seen a couple of times that has not been helpful.
I will follow up on that, which is you let your client talk at sentencing at their own peril.
Oh, yeah.
And I say that because in many of these white-collar cases, these individual defendants who want to talk don't realize, look, the fraud is over, right? And you should not be continuing with talking to me as if you're going to be, getting money from me for, an investment scheme that doesn't exist. And so I think that the mistakes that I've seen is defense attorneys simply letting their clients talk without having properly sort of supervised that process, and then sometimes telling the client, you just really can't present yourself in a way that's going to be particularly helpful, so maybe you shouldn't speak at all. Because I will tell you more often than not in many of these cases, they're talking themselves with every word into another month in custody, right? Because they don't know how sometimes to stop it, right? It's too fresh or whatever it is. And I will just tell you all, as much as, they have a right obviously to speak, but, and I want to hear from them, but you really want to be very careful about preparing your client for speaking. And I also ask questions when they speak. I'll say, well, here's a question or two questions that may be helpful for me to understand, right? Why did you do this? But, and so that's just one thing I would say.
What about anything about cautions regarding the witnesses, the stream of witnesses they want to bring in at the sentencing phase to talk about their character and their upbringing and all that kind of thing?
Well, it's not unique to white-collar cases, but just what I see often, people naturally minimize their involvement, and so you have family members or friends come in to talk about how wonderful the defendant is, and it's pretty clear they really don't have a clue about what happened, right? So, I mean, to some degree, if you're going to have people speak, you want to make sure. I always wonder if defense counsel, if they know what this person is going to say when they get up there, and maybe have a frank discussion in advance. One issue, though, that in the white-collar cases that I see come up, I would say for both prosecution and defense, you have to give more thought to the victims in those cases, because often there are a large amount of victims, and they want to be heard. And it seems to me, well, from the prosecution side, state courts where you're used to dealing with identifiable victims, they do a pretty good job of having witness coordinators and having outreach to the victims to make sure they understand what's happening. I don't see that the same on the federal court. Perhaps that's because often in these crimes there aren't identifiable victims in the way that there are in state court. So, but there's less contact with the alleged victims. And even from the defense side, to prepare a great trying to think of the right word. When you're at the sentencing hearing and you're going to argue on behalf of your client, you do have to keep that in mind, because often I've seen situations where victims have shown up in court. And in one case, there were many, and they're telling me, they have receipts and things. I'm like, why haven't you talked to the government? Well, no one's talked to me. I don't know, as someone said before, sometimes it can be tone deaf to not at least acknowledge, I'm not talking about the defendant's allocution, but for the attorney to acknowledge perhaps the difficulties that the victims have had. So sometimes people kind of gloss over it, but as judges, we won't and shouldn't.
Judge Becerra.
I mean, acceptance is an interesting concept for white-collar cases, I think, right? You get somebody who's, got 5 priors and got caught with a bag of cocaine, and they got no problem saying what I did was wrong, and I'm asking for your mercy. You get a guy who embezzled, $50 million out of Medicare, and I get a speech about how unfair the prosecutor's been, right? No, dude. I mean, I had one not too long ago where when I got off the bench, I thought, think if I had more experience, I might have taken his 3 points of acceptance away from that guy, because what was that, right? So I think some, on the white collar cases especially, maybe some clients just need to say, thank you, judge, or thank you for your time, but I decline to make a statement, right? Unless you really think that they can deliver the acceptance part, think about it. I would say as lawyers, 80% of the argument from some defense lawyers is he's nonviolent and has no priors. And I kind of want to say, I knew that already, and so what, right? Like, he's got no priors, which is why he's a 0-point offender. I already looked at that. I know he has no priors. And I know it's not a violent offense. I knew that. But the guidelines are still giving me 33 months. So if that's all you've got, you're going to get 33 months, right? Like, that's not an argument, right? That they're nonviolent, and what's the purpose of putting this person in jail? Well, I don't know. What's the purpose of putting anybody in jail? Like, do you want to have that philosophical discussion with me? Because you don't. Because I didn't become a federal district court judge because I thought I was going to be shy about putting people in jail. I knew that's what I was going to do. And so I'm not worried about doing that. In fact, I'm duty bound to do it. So that's not going anywhere. So don't put this guy in prison because he's got a college degree. It's why he shouldn't have done what he did. Like, some of those arguments to me completely run the other way. The 15 people in the audience who are going to say how wonderful he is and his college degree and that he's never done this before and he's 50 years old and had a great business, I'm thinking this is starting to sound like an upward variance, right? And so, again, I know it's a white collar case. If you're really asking for a variance, these old arguments, I think they're just old, right? Of they're not violent, they have a college degree, this serves no purpose. I don't think, at least with me, that's going nowhere.
That's interesting as you were saying that, and I think Judge Bower mentioned that the person he was talking about did a plea. Those notions about what criminality looks like, many of those things are sort of, they run throughout the community. I'm wondering, when you are dealing with this white collar criminal who's, taken the Medicare things or whatever, and you're dealing with a jury, do you find that jurors seem to look at this sort of segmented views and definitions of what is criminality? I think they try to follow the law once they understand it. But do you think that jurors have a hard time with seeing the guy with the nice suit and the college degree and who speaks the King's English, really seeing the conduct engaged in by him as, criminal, justifiable of punishment? I know they don't know what the punishment is going to be because they don't need to, but they don't sentence. I mean, they may not know how many months or whatever, but they do know that it's because you're going to read them the statute. Do they have difficulty with that?
I don't think so. I think jurors follow the law. I don't think so. And in fact, just kind of colloquially, when people talk to me, family members, right, people who aren't lawyers, about the things that make them really upset, it's the white collar cases that make them really upset, like guns and drugs. It's like everybody knows it's there, whatever. Right. It's the white collar cases that people are always like, hey, did you read that? I'm like, I can't comment about it, right? That's what's. So no, I don't think. I think juries get it.
I have had white collar criminal defendants argue strenuously. The lawyers argue to keep out evidence of a defendant's wealth because it's prejudicial against them, so that juries are more likely to find guilt in a white collar fraud or accounting fraud or whatever. And in some situations, I think there is some possible prejudice to that. And in some situations, you have to weigh whether there's a reason, whether it's probative of something. And in a situation where their commission is affected or something by the fraud, you might have to let it in. But ultimately, I agree with Judge Becerra. The juries I've had, they follow the law, they get it right. And this is actually something that I'm not just saying. When I started almost 14 years ago, I thought it's going to be tough. What happens when the juries get it wrong? But I have not had a single situation in my 13, 14 years, where I feel like a jury got it wrong. Other than a situation where I had to cut punitive damages because they were,
outraged.
Yeah. But in my criminal cases, I think they've followed the law, and they've at least been within kind of the zone of what a reasonable jury could find.
I see head nods.
No, I would agree that I have not had a jury, I think, decide the case differently that I would expect them to, based upon the evidence that was presented. Now, they might not have seen all the evidence because some of it may have been excluded. I will say, I think, in trials, and I've done a fair number, I've actually done a ridiculous number of trials in the past few months, and I gave this talk yesterday at the opening. In closing, one of the biggest challenges for white-collar defendants, I think, particularly if you're trying to make an argument about somehow your client having been mistaken or they didn't do this intentionally, I think jurors assume sophistication for many of these defendants. And so if you're going to argue that somehow your client really didn't understand when he was supposed to pay that loan back, didn't really understand that, the sort of how he was reporting sort of the rate of return on investment wasn't supposed to be a range, that's going to be a very challenging argument for the jury to buy, because they assume that many of these defendants know what they're doing. And so I would say to all of you, if you're trying the case, if you're trying to convince a jury that somehow your client really didn't understand or know, that's a real uphill battle. And so you may want to think about ways that you can convince them of that, but I think you're starting off at a disadvantage in these particular types of cases because of the sophistication of the defendants and their background.
I promised that I was going to allow about 15 minutes of question, then I'm going to come back and give each of you 1 minute to give a takeaway tip. That's the price of having paid for this conference to this audience before we close. So right now, if anyone has a question for any of the panelists, if you will stand up and shout it out, I'll try to repeat it into the microphone. Does anyone have a question for any of our panelists?
They're all hungover.
Okay, remember you have to stand up. So Judge Lightfoot, Mayor Lightfoot.
Well, it's not really a question, but I want to respond to a comment
Go right ahead.
the judges made about the threats to them. I think it's something that we don't appreciate because marshals handle it, it's very quiet. Like, I come from the Northern District of Illinois, where Judge Lefko's family, her husband and her mother, were killed by a mentally unstable litigant who hid in her house. And obviously we're aware of what happened to the judge in New Jersey where her son was killed. But the way we speak matters. And I really appreciate your point about lawyers being a lot more cautious in the way they talk about judges. I'm an ex-elected official. I still have 2 pending criminal cases for people who thought it was okay to call and say they're going to kill me and my family. We are living in a time, frankly, probably like no other, and we can't inadvertently or intentionally undermine the rule of law by putting judges on blast. No lawyer loves what a judge does 100%. That goes with the territory. But the way in which we speak does matter, and I appreciated also the comment about, I think lawyers are uniquely positioned to be leaders in their communities, to be civically engaged, and people watch what we say. If we're good at our job, we're good advocates, but we need to be careful not to advocate inadvertently for the wrong things, and particularly when it comes to judicial safety. So I just wanted to thank you for raising that issue in this room.
Any comments from the panel? The next person who wants the microphone, if you can stand now, the gentleman will make his way up to section number 5, I guess it is. Any comments from the panel on Mayor Lightfoot's comments?
Amen.
Okay. Well, that was just enough time for him to get the microphone there. Yes?
Thank you, Your Honor.
Yes.
This question is for all of the panel. My name is Mitchell Epner. I'm a litigator in New York. How do you think about litigants who show contempt for the court, not, and I literally mean contempt for the entire process, and feel, based upon high-profile litigants who have shown contempt for courts and not been punished for it, how do you feel about the process of using your contempt powers and the possibilities that the more you do, the more you're in a fight in the mud with a pig, and the old joke that goes along with that?
These are all city folks. They don't know anything about fights with pigs. But anyway, go ahead and do the best you can.
Well, it's not just the litigants, it's the attorneys as well. One important thing, we have some we have broad discretion in how we handle these things. And the important thing is for us as judges to show restraint, not get baited into doing something that's only going to exacerbate everything. So sometimes we do have to take action, but again, someone's acting up, putting them in jail is not necessarily the most appropriate thing to do. There are different ways to handle each case based on the unique circumstances, but we have to be mindful of that, although we have this great power, that we have to exercise some restraint.
Others? I'll just say that sometimes in those extreme cases, though, you do have to resort to that ultimate sanction of putting them in jail, and that's rare, as Judge Gale said, but sometimes it'll get there. Yes.
Michael Wynn from Houston, thank you for your comments on the difficulty posed by the millions of documents that are dumped on us as defense lawyers. Two matters about which I'm curious. First is the fact, having gone through it many times, that the most critical documents, including 302s and DEA 6s, are dumped upon us in the weeks before trial. And the difficulties that poses, including after co-defendants have already pled guilty and agreed to testify. And the second thing is your comments on filter teams or taint teams, depending on your perspective, including in that context when we're scrambling, getting ready for trial, and making some really big decisions.
So I will say that I order the earlier disclosure of that material. In my district, that's more common anyway, but I allow defense attorneys to request the 302s and other statements earlier. They just make out a case for that. There is law that can and does support that, at least in my circuit. And so I think that it's appropriate to do that. I was a former defense attorney myself. It seems to me not only unfair, but puts the judge in a strange position, potentially of having to continue or delay a trial when substantive statements from co-defendants or witnesses, not from guys co-defendants, but from witnesses, are essentially dumped on the defense in the weeks before trial. I just don't think that that's appropriate or fair.
Other panelists? Is there another question from the audience? So, stand, wave your hand, and
I always tell lawyers, when I'm on the bench, I don't take questions. So this is your chance to ask a question, because if I have my robe on, you're not going to get a chance to ask me a question.
Thank you, sir.
I'm just curious about what kind of information you find most valuable in sentencing. Do you like to look at what other sentences have been for people with similar crimes in the same jurisdiction, or do you even consider other sentences from similar people from other jurisdictions? Do you like to look at information about what percentages of sentences have been within the guideline range for particular offenses? Is there any particular type of information that you're given by some practitioners that you think stands out and makes for a more effective sentencing presentation?
I do think information about similarly situated defendants is very helpful, and I do look at that. And I wouldn't limit yourself to the district. We were talking yesterday about IEPA cases, and sometimes there's kind of a random smattering all over, and I think it's helpful to get information. I look at that, and our pre-sentence reports now have an added section on all prior defendants who are not cooperators in this range, what they actually received in our district and nationwide, and I find that very helpful. Generally, I find whatever you give us, whatever you have to work with. I mean, letters can be helpful. Obviously, I don't think I need 100. I think 10 to 15 is enough. I do consider mitigating factors about someone's life, with the caveat I mentioned earlier. If you have extraordinary acts of charity and good work, I mean, I'm happy to hear about that, and that could matter.
Other comments? Oh.
There is one thing I was going to say, which
Okay.
is, in addition to the Jason comment, there's something on the Sentencing Commission website called the Interactive Data Analyzer. Have any of you heard of this? If you have not, it allows you within a district to compare sentences by age, by race, by gender, by criminal history category. And I find that type of information, which is much more, I think, accurate in certain respects than the Jason information, to be very helpful. And very few defense attorneys actually use it, but it's available on the Sentencing Commission's website. It will tell you, even within the district, what different judges are doing. Again, it can tell you by race, it can tell you by gender, it can tell you by age, it can tell you a whole list of variables with which to compare individuals. And so I would strongly encourage you to take a look at that if you haven't. It's called the Interactive Data Analyzer.
Before I take the next question, I just want to say that the American Bar Association's criminal justice section has for years had an implicit bias initiative, and I was one of the lead trainers in that initiative. And so I've had an opportunity to talk to a lot of judges, and behind this speech is a question. So I would suggest to judges that, we have all these biases, all of us do, and some of them we may not even be cognizant of. But I would say to them, it's probably not a good idea to set like a whole day of sentences, because, when you do those back to back, sometimes it makes it easier for our stereotypical beliefs to go unchecked. And a lot of things can come to bear on that we may not be knowledgeable of. And I just wanted to ask for this group, do you disperse your sentences throughout the week or whatever, or do you have a sentencing day and you try to dedicate one day? Just quick thought about what you do and how you do it. Judge Gales?
Well, I plug them in when I can, because
Plug 'em in where
we have
I
a pretty
can.
busy trial schedule,
Yeah.
and so I don't have a sentencing day per se, but sometimes to accommodate my trials, I have to put, say, sentencings on Fridays so that I can try a case Monday through Thursday. But I think being mindful of the issues that you talked about are important, and sometimes we need to take a break, or we're in the moment we need to, like if we have a very difficult sentencing or with a very difficult defendant, then maybe going right into the next sentencing is not the appropriate thing to do. So for us, being mindful of those things is really important.
Okay. Not everybody has to answer, but if you want to say something, you can. Then I'm going to go to this gentleman.
I disperse them only because they're exhausting.
Yes.
Even an easy sentence is still hard, so I try to disperse them. It turns out that some days I do have 2 or 3 in a day, because like last week I was at a training, so I'm gone a whole week. Like it just created that for this week. So I try to disperse them when I can. I will say that on the Jason data, like more data is good. Like I find it helpful. What I find most helpful, though, is when a defense lawyer can say to me, this defendant looks a lot like a defendant that Judge Gales sentenced 6 months ago, or Judge Williams, or Judge Moore, somebody in my district. Because I was a prosecutor in DC without guidelines, and I have a particular sensitivity to the fact that I don't want a defendant to think, wow, he was in front of Becerra, and he got 100 months. If he had been in front of Gales, that would have been 50, right? Like, so that comparative data for me is really important, and especially the public defender's office has got that more readily available because they talk to each other. I think is really helpful because I'll go to those dockets and look at that PSI and say, well, I was thinking of giving that guy 70 months. Why did Judge Ruiz give somebody like that 54? Oh, I know why. I can see the difference, or whoa, there's no difference. So I think that's important. And for me too, the details of the person, because if you're asking me to give an outside of the sentence guideline, I'm now thinking, because especially since I'm new, I'm thinking, is this what I'm going to do in this kind of case for the next 12, 13 years? Because there are some groups of cases where I can say, I'm going to downward depart or vary in these cases because this type of case doesn't merit this type of sentence. Okay, that's one. But if you're giving me somebody who's a felon in possession and I know I'm going to have 300 of those before I hang up the robe, and you want me to do something that's not a guideline sentence, there's got to be something about your defendant, not the crime, right? Because that's just something I'm going to see too much. And if there's something about your defendant, then I know that I can hang my hat on that issue because that's not an issue I'm going to see again. So if you want that, help me articulate what it is that factor. Sometimes I think defense lawyers, the stuff is just too generalized, and that's not helping me compare because I'm very sensitive, and again, I think it's because I was a prosecutor in DC for a while. I'm very sensitive to that disparity issue in particular because I have, when I was in DC, people would be like, oh, you got Judge so-and-so, don't worry about it. So give me something that's detailed. The general stuff, I need to hear it too, but it's not going to get you anywhere, I don't think.
Okay, we have a question over here, and then after that, I'm going to give the panel, after they respond to this question, their 1 minute to close. Yes, sir.
Thank you very much. Bill Sullivan from Pillsbury, Winthrop in Washington, D.C. I've had a variety of different experiences in various jurisdictions, so I'm wondering if you have a perspective as to whether a prosecutor fulfills his or her Brady obligations by making a voluminous document dump on the defense without specifically delineating exculpatory material.
I'm not going to express a view on that because that might come up before me.
if it hasn't already. I would say I think it depends upon the nature of the case. I think as a general matter, if it appears that someone is trying to effectively hide information, right, and there's standards and case to talk about, that's one thing. But oftentimes part of the issue for us as judges dealing with that sort of massive discovery is that the prosecutor's office don't always have good tools for organizing the material themselves, absent pointing out very specific documents. So absent pointing out particular statements of a defendant or co-defendants, they may not always have good tools. Now I have, and you can request this, it's something you should think about, I have requested and ordered the prosecutor's office to provide an organizing chart of what they have provided, at least by category. So for example, if it's emails of a particular individual, and they've already had this category, I'll ask them this, to provide that without it being, because I don't think that's necessarily work product or privilege in any way, if it's just organizing material. So that's something you may want to think about, just requesting. I'm not sure about the issue of sort of exculpatory material. I think that's a case-by-case basis, but I think you can certainly request an index or some sort of categorization if it exists.
Okay, thank you, sir, for that question. And I know we started just a few minutes late, but we're not going to hold you too long. You have a panel of judges who are in here doing the day-to-day work. They're experts at their craft. They come from jurisdictions around the country here. And so I've asked them to sort of think about if there's one tip, takeaway they could give you that will help you by being mindful of or avoiding, just whatever wisdom they would give to you before this session ends. And that's what we're going to get to now. Was that somebody? Oh no, that was not somebody standing up with a question. So for the panel, first of all, we want to thank you for being here today and for engaging the audience and addressing these topics and giving us the benefit of your thinking on this. We know that you have a busy schedule and that you're every day engaged in working in a manner that instills confidence in the judiciary, that promotes justice and equality, and that promotes the expeditious resolution of the issues that come before your docket. All of that, you know, we're grateful to you for. But now I want you to think about a word of wisdom that you would leave this audience with as you depart this stage. And I don't want to call on you, so whoever wants to start first.
I'll give a tip and a cautionary tale,
Thank you.
which is, and this is sort of focused on sentencing. Make sure that what you say has truth, and make sure you've done your homework to establish that truth. And this is a story I told on the panel yesterday as well, which is last year, or maybe the year before, I had a white-collar defendant, retained lawyer at sentencing. The submission was all about what a great person he was and a great father, and just letters from his 4 kids, and went on and on. And there was one thing in the letter from his daughter that struck me as odd, which was that she had been an NYPD police officer for several years and then kind of left under unfortunate circumstances. So I just happened to look on ECF and query her name, and I found that sure enough, she had been convicted of taking bribes as a police officer. I said, oh, that's interesting. And I was just bored one day, I guess, and I decided to look at her sentencing submission, which was also in our district. And her sentencing submission was all about how her father had physically and sexually abused her throughout her entire childhood, even though she had written a letter saying what a great father he was. So if, I don't know how the lawyer would have made sure that would have come out, but at least the lawyer should have checked ECF, because there it was. And so I had to have put off the sentencing and have the lawyers address how this came out. The government had missed it. I just happened to find it. So be careful, do your homework, and make sure there's truth to what you're submitting.
So I think our courtrooms and our legal system is such a reflection of what our society is, and we are living at a time where people just will say anything, right? Between just email, Snap, whatever, people are just out there, they say what they think, and they're not interested in any kind of discussion about their position. And I find that sometimes I'm sitting on the bench and I'm thinking, are people just like reading their, like if this is like Snap or Facebook or something like that? The art of coming into my courtroom and the art of litigating is to persuade me. And so oftentimes lawyers get up, they say what their position is, as if it's just like a statement, as opposed to an effort to convince me that they're right. And I find that happens so much. I have lots of oral arguments because that's how I think, by talking, so I want to talk to the lawyer. And like I'll ask a question and it's like I didn't ask the question. It's like nobody's listening. Or I'll have a lawyer get up and make a really good argument and the other side gets up as if this guy just didn't say anything. And so people just come in, and I see it in the written briefs, but I see it also in oral argument. People they're there, they say their piece and they want to sit down. And it's like, no, you're supposed to convince me. You're supposed to be able to articulate why that is your position. I have to write an order. Sometimes I'll say to lawyers, I have to write an order. What would my order say if I agreed with you? And so listen. I'll leave you with that. Like, just please listen. Listen to each other, listen to the judge, listen to your clients. Just take a minute to listen as opposed to just stating something.
Your Honor, I'd be happy to give you a copy of my arguments if you would like to reduce it to writing. So, yes, next.
Well, I think I've already sort of given my advice by the different things that I think that you all should think about as it relates to both sentencing, allocutions, as it relates to also educating judges about complicated technology issues, as well as exploring discovery issues early on. So I think those are all important things for practitioners to be mindful of.
Judge Gales.
Oh, and just briefly, I would say, know your judge. You know, Judge Becerra and I are across the hall from one another. We've known each other for a very long time. We're friends. But we are not exactly the same. You know, and I think, you know, like, for example, a judge may be swayed or moved by a beautiful video at sentencing going over the defendant's life. To me, that doesn't, I'd rather hear from a live person. So kind of give some thought to knowing your judge and what he or she likes. There are going to be lots of people that can talk to you about that. And also, to borrow a phrase from one of my more senior colleagues, judges don't like surprises. If you've got, in these complicated cases, an issue that's going to come up in trial, make sure you let us know ahead of time so we can give some thought to it and we're not ruling on the fly.
Thank you. One thing I will add, I think Judge Bulwer started off with technology, and he certainly covered that. But one of the things I would say to you, if you're going to be trying something to a jury, make sure that you are mindful of how you need to communicate that, and I think this group has already talked about that. If you're dealing with, you know, complicated concepts, if you're using an expert or something to someone to communicate that, make sure that that expert is acutely aware at all times that they are communicating to the jury and that they're not simply trying to show you and others how great they are. The people need to understand what is being communicated. And please caution them, do not come in, even if they are the greatest, whatever it is that they're testifying about. Jurors are often put out by people who are condescending, and if they communicate that information in a way that is condescending, I mean, your money is just lost on that person. Maybe it can do something when you're going to the judge for, you know, your motion for a new trial, but jurors are really offended. It may be that they come from a broad swath of the country, and maybe they are at a 10th grade level, but they are offended when, you know, Dr. such and such comes in and is looking down on them and talking to them. So they want to understand, because they really want to do a good job. They really want to get it right. And so your job, of course, is to present that information to them so that it aids them in understanding, so they can make a decision based on the evidence and on nothing other than that. And if you're using technology throughout your presentation or at any part of it, make sure that the technology supports what you're doing and does not become the object of the thing itself. I can tell you the number of times that I had people come in to use technology to present something, and they've used it in closing argument, and all of a sudden the technology became a barrier. And don't get new technology and come into this situation using it for the first time. If you don't understand it and don't know how to do it, make sure that you bring the person who does know and who can get it up and going again quickly, because the judges don't want to sit and wait while you tinker. So those are my thoughts this afternoon. And unless there's something else from this incredible panel, please join me in thanking them for a marvelous presentation. Thank you.
Thank you.